If you are an immigrant living in the United States right now, or if you have family members who are immigrants, or if you are currently in the process of applying for any kind of immigration benefit, then you absolutely need to stop everything you are doing and listen very carefully to what I am about to share with you today. The information in this video could fundamentally change your life, your family's future, and your ability to remain in this country legally. February of 2026 is approaching faster than most people realize, and the immigration landscape in America is about to undergo some of the most significant transformations we have seen in decades. I know that many of you watching this video right now are feeling anxious and uncertain about your immigration status. You have been hearing rumors, reading conflicting information online, and perhaps even receiving advice from well-meaning friends and family members who may not have the most accurate or up-to-date information. That is exactly why I created this video today. I want to cut through all of the noise, all of the confusion, and all of the misinformation to give you a clear and comprehensive understanding of what these immigration law changes actually mean for you and your loved ones. Before we dive into the specifics, I want to make something very clear. Immigration law in the United States is incredibly complex, and the changes that are coming in February of 2026 affect different categories of immigrants in different ways. What applies to one person may not apply to another, depending on their visa status, their country of origin, how long they have been in the United States, and numerous other factors. So while I am going to provide you with as much detailed information as possible in this video, I strongly encourage you to consult with a qualified immigration attorney who can review your specific situation and provide personalized guidance. Now let us talk about what is actually happening and why February of 2026 is such a critical deadline for millions of immigrants across this country. The changes that are being implemented touch on virtually every aspect of the immigration system, from visa applications and renewals to green card processing, naturalization procedures, public charge rules, and enforcement priorities. This is not just a minor policy tweak or a small administrative adjustment. This represents a fundamental restructuring of how the United States approaches immigration, and if you are not prepared, you could find yourself in a very difficult situation. One of the most significant changes that immigrants need to be aware of involves the public charge rule and how it is being applied to benefit applications. For those of you who may not be familiar with this term, the public charge rule is a provision in immigration law that allows officials to deny certain immigration benefits to individuals who are deemed likely to become primarily dependent on government assistance. This rule has existed in some form for over a century, but the way it is being interpreted and enforced is changing dramatically. Under the new guidelines taking effect in February of 2026, immigration officials will have expanded authority to consider a wider range of factors when making public charge determinations. This includes not just cash benefits like temporary assistance for needy families or supplemental security income, but potentially other forms of government assistance as well. The income thresholds are being adjusted, the documentation requirements are becoming more stringent, and the overall scrutiny of benefit usage is intensifying significantly. What does this mean for you in practical terms? If you are an immigrant who has used certain government benefits in the past, or if you are currently receiving any form of public assistance, you need to understand exactly how this might affect your ability to renew your visa, obtain a green card, or eventually become a naturalized citizen. Many immigrants are completely unaware that their benefit usage is being tracked and could potentially be used against them in future immigration proceedings. This is not meant to scare you unnecessarily, but it is meant to inform you about the reality of the situation so that you can make informed decisions about your future. Another major change that is causing significant concern among immigrant communities involves the visa renewal and extension process. Starting in February of 2026, new procedures are being implemented that will affect how visa holders apply for extensions and renewals of their status. The processing times are expected to change, the documentation requirements are being updated, and in some cases, in-person interviews that were previously waived may now be required again. For immigrants who are currently on work visas, student visas, or other temporary status categories, this is particularly important information. If your visa is set to expire in the coming months, you need to start the renewal process as early as possible. Do not wait until the last minute thinking that you will have plenty of time. The new procedures could result in longer processing times, and if your visa expires while your renewal application is pending, you could find yourself in a very precarious legal situation. I have been receiving messages from viewers all across the country who are panicking because they did not plan ahead and now find themselves scrambling to figure out what to do. Please do not let this happen to you. Take action now while you still have time to prepare properly. Gather all of your documentation, consult with an immigration attorney if necessary, and submit your applications well in advance of any deadlines. The changes to the green card application process are also significant and deserve your full attention. The pathway from temporary visa holder to permanent resident is becoming more challenging in several important ways. Background check procedures are being enhanced, which could result in longer processing times. The evidence requirements for employment-based green cards are being tightened, meaning that applicants will need to provide more extensive documentation of their qualifications, their job duties, and their employer's need for their specific skills. For family-based green card applications, the scrutiny of relationships is intensifying. Immigration officials are being given more tools and more authority to investigate whether family relationships are genuine or whether they might be fraudulent arrangements designed to circumvent immigration law. If you are sponsoring a family member for a green card, you need to be prepared to provide extensive evidence of your relationship, including photographs, communication records, financial records, and potentially testimony from friends and family members who can vouch for the authenticity of your relationship. The naturalization process, which is how permanent residents become United States citizens, is also undergoing changes. The civics test is being updated with new questions, and the passing requirements may be adjusted. The English language proficiency requirements are being reviewed, and some exemptions that were previously available may be modified or eliminated. If you are a green card holder who has been thinking about applying for citizenship, now might be the time to seriously consider moving forward with that application before these changes take full effect. One aspect of the February 2026 changes that is causing particular anxiety in immigrant communities involves enforcement priorities and procedures. The way that immigration enforcement is being conducted is shifting, and this affects not just undocumented immigrants, but also those who are in the country legally, but may have minor violations or issues with their status. The consequences for even small infractions are becoming more severe, and the discretion that was previously exercised by immigration officials in certain cases may be significantly reduced. For immigrants who have any kind of criminal record, even minor offenses that occurred many years ago, this is an especially critical time to review your situation with a qualified attorney. Offenses that might have been overlooked or considered insignificant in the past could now trigger serious immigration consequences. This includes things like old traffic violations, minor drug offenses from years ago, or other issues that you may have thought were long behind you. Do not assume that because nothing has happened to you so far, nothing will happen in the future. The enforcement landscape is changing, and past conduct is being reviewed with fresh eyes under new guidelines. I want to take a moment to address something that I know many of you are feeling right now: fear, anxiety, uncertainty about the future. These are completely understandable reactions to the news of significant immigration law changes. Many of you have built your entire lives in this country. You have raised families here, built careers here, contributed to your communities here. The thought that your ability to remain in the United States could be threatened is genuinely terrifying, and I want you to know that I understand and empathize with what you are going through. However, I also want to encourage you not to let fear paralyze you into inaction. The worst thing you can do right now is stick your head in the sand and hope that these changes will not affect you. Knowledge is power, and by understanding exactly what is changing and how it might impact your specific situation, you put yourself in the best possible position to protect yourself and your family. Take the information from this video as a starting point and then do your own research. Attend community information sessions if they are available in your area. Consult with immigration attorneys or accredited representatives who can provide reliable guidance. One resource that many immigrants overlook is the official information available directly from United States Citizenship and Immigration Services. While the USCIS website can sometimes be difficult to navigate, it contains a wealth of accurate and up-to-date information about immigration procedures, requirements, and changes. Before you rely on information from social media, from friends, or even from paid consultants who may not be legitimate, always try to verify what you are hearing against official government sources. Speaking of people who may not be legitimate, I want to issue a strong warning about immigration fraud. Whenever there are significant changes to immigration law, fraudsters and scam artists come out of the woodwork trying to take advantage of frightened and vulnerable immigrants. They promise quick fixes, guaranteed results, and special connections that can supposedly help you avoid the consequences of the new rules. Do not fall for these scams. There are no special shortcuts or secret pathways that these people can provide. All they will do is take your money and potentially make your immigration situation even worse. Only work with licensed attorneys or accredited representatives who are authorized to provide immigration legal services. You can verify whether someone is legitimately authorized to provide immigration assistance through various state bar associations and through the Department of Justice, which maintains a list of accredited representatives. If someone is pressuring you to pay large sums of money up front, promising guaranteed results, or asking you to sign blank forms or documents that you do not understand, these are major red flags that you are dealing with a scammer. As we approach February of 2026, there are several concrete steps that every immigrant should be taking right now to prepare for the changes ahead. First, make sure that all of your immigration documents are current, organized, and easily accessible. This includes your passport, your visa documents, your employment authorization card if you have one, your green card if applicable, and any other immigration-related paperwork. Make copies of everything and store them in a safe place separate from the originals. Second, review your immigration history carefully. Are there any gaps in your status that you need to address? Any violations that you need to disclose? Any old issues that might come back to haunt you under the new enforcement priorities? It is better to identify and address these issues proactively rather than waiting for immigration officials to discover them on their own. Third, if you are currently receiving any government benefits, consult with both an immigration attorney and a benefits counselor to understand how your benefit usage might affect your immigration status under the new public charge rules. You may need to make difficult decisions about whether to continue receiving certain benefits, and you should make those decisions based on accurate information rather than rumors or assumptions. Fourth, if you have been putting off any immigration applications or processes, consider whether now is the time to move forward. If you are eligible to apply for naturalization, think seriously about doing so before the new requirements take effect. If you need to renew a visa or extend your status, start that process as soon as possible to avoid any gaps or problems. Finally, stay informed as the February 2026 deadline approaches. Immigration policy can change quickly, and there may be additional announcements, clarifications, or modifications to the changes that have been announced. Subscribe to this channel so that you do not miss any updates, and make it a habit to regularly check official government sources for the latest information. I know that this has been a lot of information to absorb, and you may be feeling overwhelmed right now. That is completely normal. Immigration law is complex, and the stakes are incredibly high for you and your family. But please remember that you are not alone in this. Millions of immigrants across this country are facing the same challenges and uncertainties that you are facing. By educating yourself, preparing proactively, and seeking appropriate help when you need it, you can navigate these changes successfully. Before I end this video, I want to remind you one more time how important it is to act now rather than waiting. February of 2026 may seem like it is far away, but when it comes to immigration matters, time has a way of slipping by faster than you expect. Applications take time to prepare. Processing times can be unpredictable. Appointments with attorneys or immigration officials may need to be scheduled weeks or months in advance. Every day that you delay is a day that you lose in terms of preparation time. If you found this information helpful, please share it with other immigrants in your community who need to know about these changes. Many people will not see this video on their own, but if you share it with your friends, family members, co-workers, and neighbors, you could help them protect themselves and their families during this critical time. We are all in this together, and by looking out for each other, we can get through these changes as a community. Thank you so much for watching today. Please take care of yourself and your loved ones, stay informed, stay prepared, and stay hopeful. Despite the challenges ahead, this remains a country where immigrants have always found ways to build better lives for themselves and their families. With the right preparation and the right information, you can continue to build that better life for yourself and for the generations that will come after you.